Hello and welcome to PraDa Law Live. I'm your host, Jackie Mendez. Today we have an excellent show lined up for you. I'm going to go ahead and introduce our attorneys, but before I do that, I want to remind you there's a number on your screen, 888-88-LEGAL. The call is free. The consultation is free. And today we're going to be talking family law as well as criminal law. And I want to go ahead and introduce our attorney, Mike Haber.
Good morning.
And he is our criminal attorney, ladies and gentlemen. One of our partners here at PraDa Law, Daniel Silver.
So it was a pleasure to be here. Thanks, Jackie.
He is going to be talking to us about family law. And of course, the lovely Jennifer Pratt, one of our partners here at PraDa Law.
Thank you, Jackie. You're too kind. And good evening to all. We're very excited to be here talking about family and criminal law today.
That's right. Ladies and gentlemen, before we kick off the show, I just want to remind you once again that there is that number right there on your screen, 888-88-LEGAL. Give us a call. The consultation is free, and we're ready to hear from our attorneys.
That's right. And today we have a jam-packed filled show. We're going to be talking about family law as well as criminal law and the intersection between the two. And I want to start off the show by just reintroducing attorney Michael Haber. He has been an attorney here in the community for many, many years. Is very experienced in all types of criminal cases. And I'm going to have you start off, attorney Haber, because I know you and attorney Silver prior to the show were talking, and you guys have some ideas of things that you want to educate the public about today. So tell us a little bit about what you guys were talking about before the show commenced.
Thank you very much. Dan and I were talking a little bit about statements, and I guess anybody who's ever watched any kind of a police TV drama, you know, whether it's an older Starsky and Hutch type thing or Beretta or something more current, has heard the famous Miranda statement that anything that you say can and will be used against you. And so Dan and I were kind of kicking that around in the context of the crossroads between criminal and family law. The last time that we were here, we talked a lot about domestic violence, and it's a good focal point as any, but the idea that anything you say can and will be used against you doesn't just apply to the police. And so that was where Dan and I had begun our discussion earlier. And the rules are a little bit even more perilous, so to speak, in the family context, as I understand it, than they are even in the criminal. Is that?
Absolutely. So we hear, in TV shows such as like Miami Vice would be a better example. But regardless, we have any statement that's made out of court is a hearsay statement. But like every rule, there are exceptions. So there's a hearsay rule, and there are exceptions to the hearsay rule. But in family court, what you need to know is that anything that you say to your spouse can be used against you in family court. It's called an admission of a party opponent, the party opponent being your spouse. So if you said something out of court to your spouse about your child, about finances, about agreement, whatever you're saying out of court, then your spouse may be able to testify to that against you in family court proceedings.
That's right. Yes. Go ahead, Mike.
You know, I guess in family, it's probably the same as in criminal. It even goes beyond just the spouse, right? Because in criminal, you don't want to make statements to the police, right? They're the ones who have to give you the warning, because that's what the Fifth Amendment says, right? The Constitution says you can't be compelled to be a witness against yourself. So the cops are required to give you that warning. And if they don't, there are potential remedies and consequences. But what about statements that you make to people who are not cops, right? Those statements might be introducible against you in the criminal context, and I would assume that the same, must hold true in family as well.
Well, again, with every rule, there's exceptions to the rule. So if if we're talking about statements made to third parties that are not your spouse, if we're talking about, for example, you have a neighbor and that neighbor has either heard you made statements or maybe you've sent text messages, that neighbor is going to have to come in to testify. That third party is going to have to come in to testify. Well, one thing I wanted to, that kind of caught my attention, when in criminal court, you have obviously your Fifth Amendment right, where anything you say or don't say, it can't be held against you. But in civil court or in family court or domestic violence court, if you invoke the Fifth Amendment, you're basically giving the other side what's called the adverse inference. So even though you're not saying anything, because you're not saying anything, the judge can hold that adverse inference against you, unlike in criminal court.
And really interestingly, in criminal court, we work very hard to vet our juries before they become jurors on the importance of the Fifth Amendment and the fact that they are not allowed, they're specifically prohibited from having any kind of inverse inference if the defendant chooses not to make a statement. So if, let's say, my client says, I'm not going to testify, well, the jury needs to be instructed very strongly by the judge, hey, you can't take the fact that the defendant is not testifying and use it against him and figure, well, if he had something to say, he'd be up here saying it. The fact that he's not defending himself, he must be guilty.
Thank you so much, Attorney Haber and Attorney Silver. Very valuable information. I just want to remind our viewers at home that the consultation is free. The call is free. Give us a call, 888-88-LEGAL. Our lawyers are ready and willing to help you in any of these cases. Jennifer?
Thank you, Jackie. So interesting, the complexity of the same rule being applied in the civil family context versus criminal context. Attorney Silver, I know you and I were talking earlier this morning about one of the cases in our law firm, and we were talking about statements that a child makes, a minor child, and whether or not in the context of a family case, and I'd love to hear from Attorney Haber as well, whether or not children can be made to testify and what sort of parameters courts will look at. Oftentimes we have parents that come to the office and say, if I could put my son or daughter on the stand, they'll tell you he's a drunk, they'll tell you he does this, he does that. Attorney Silver, what are some of the issues with having children testify? Is it like a black letter? Like, are they just never, ever going to testify? Under what kind of circumstances in the civil/family context can we see children testifying? And if so, is age a factor? Is the subject matter the matter? What is it that can, I guess, make or break the possibility of a minor child testify? And keep in mind, Attorney Silver, that we've got about 20 seconds before the break, so leave the good stuff for when we come back after the break. But just briefly.
Briefly, the 20-second answer could require a 20-minute explanation. But regardless, kids don't come to court. Kids are not brought to court. You need permission from the court in order to have a minor child testify before the court. The courts do have the authority or the discretion to allow a child to testify.
We want to hear all about it. We'll be right back before the break, after the break.
I know you're home right now asking yourself, how? How will I pay my rent, my mortgage, my bills, my credit card debt? I'm attorney Alexis Garcia with PraDa Law. I've personally helped people with financial problems over the last 10 years. I understand what you are going through. We saw people lose it all in the 2008 financial crisis. You don't have to lose it all. The consultation is free. Call us now. I will help protect what you have built. You have nothing to lose by calling us. Call us now. These are trying times. This deadly virus is affecting our health, economy, jobs, our small business owners. Bankruptcy protection may be able to save assets and immediately stop your creditors from harassing you. Small business owners, employees of business of any size, we know you need help. Call us now. We will help you get back on your feet. Don't wait until it's too late. This is the time to call.
Sé que estás en la casa ahora mismo preguntándote, ¿cómo? ¿Cómo voy a pagar la hipoteca, la renta, los biles, las tarjetas de crédito? Soy la abogada Jennifer Pratt con PraDa Law. Yo personalmente he ayudado a las personas con problemas financieros durante los últimos 10 años. Yo entiendo por lo que estás pasando. Vimos cómo la gente lo perdió todo durante la crisis financiera del 2008. No tienes que perderlo todo. Llama ahora. La consulta es gratis. Te ayudaremos a proteger todo lo que has construido durante todos estos años. Sabemos que estos son tiempos difíciles. Este virus mortal está amenazando nuestra salud, nuestra economía, nuestros empleos y a los propietarios de nuestras pequeñas empresas. La consulta es gratis. Llame ahora. Te ayudaremos a recuperarte. No esperes hasta que sea demasiado tarde. Llame ya.
And we're back. This is PraDa Law Live. I'm your host, Jackie Mendez. Ladies and gentlemen, we've been talking criminal law with Attorney Haber. We've been talking family law with Attorney Silver. This is PraDa Law Live, and there is a number on your screen, 888 888-88-LEGAL. Give us a call. That consultation is free. The call is free. We're willing and ready to answer any questions that you may have. Jennifer Pratt is going to go ahead and lead us back into the conversation.
Thank you, Jackie. And before the break, I just want to apologize to Attorney Silver. I didn't mean to cut him off, but production was going to cut me off if we didn't get to the break. And so that's why time is very important, because time is money and we got to get with the program here. So let's jump right back in, because it's really important what Attorney Silver was talking about, because this is a question we get asked very often in family context. And then I want to hear from Attorney Haber. And the question before the break was about children testifying, whether this happens, if they do, at what age, and in what capacity. Take it away, Attorney Silver.
So when you talk about a child could be 5 years old, 10 years old, 15 years old, and that's going to make a huge difference. But regardless, as a blanket rule, children are not brought to court to testify, and if a child's going to testify, it needs the court's permission. And more often than not, a court is not going to want to hear from a child directly. A court is going to appoint a guardian ad litem or some third party to talk to the child and then convey that information. And this happens so frequently because when you have parenting disputes, the main witnesses are the mother and the father. Both parents are going to be biased against each other, and a court is going to want to hear from a neutral third party as to what's in the child's best interest, rather than have a full-day trial of a he said and a she said.
But why can't they just hear directly from the child? The child was there. The child witnessed it. They lived this case. Why not?
Because if you have a 5-year-old child, that would certainly be detrimental to the child, and there may be trustworthiness issues as to the testimony. But if you've got a 17-and-a-half-year-old child, well, that child may be able to testify to the court because he's going to be an adult in 6 months.
Silver. Ladies and gentlemen, 888-88-LEGAL. The call is free. The consultation is free. We have offices all over the United States, and we're ready and willing to help you. So give us a call. Don't hesitate. Thank you, Jackie. What about in the criminal context, Attorney Haber? What are thoughts about children, whether it could be anywhere from, if they're the victim, all the way from a witness to a crime? Is it common in the criminal courts to see children testify? And if so, what are some of those parameters or circumstances whereby a judge may allow a child to testify?
So judges have great discretion. They get to decide whether or not a witness is competent to testify. And when it comes to children, that's really the number one rule, is competence. Are they able to get up and tell the truth? Do they know what the truth means? Or are they just going to get up there and repeat a story that they've been coached? And so what normally happens in the criminal context is that the judge, if asked to do so, will conduct what we call an in-camera inspection. In other words, they'll have a little meeting with the child. They'll go into chambers, one-on-one. Perhaps they'll take the guardian. They do appoint guardians in criminal as well if the child is young enough or in need. And then the judge will actually sit down and have a conversation with the judge as to whether or not this child is capable of distinguishing between right and wrong and understands the difference between a truth and a lie. We just litigated a child abuse case not too long ago where we had a 6-year-old child victim, and that child did testify. The judge ruled that the child was able to determine right from wrong after conducting that in-camera hearing with the child. And interestingly enough, the testimony was performed in chambers on the judge's couch. The defense lawyer and the prosecutor were the only two people in the room with the child. The room was set up with video, kind of like we're being, recorded here. And it was live streamed into the courtroom where the jury was able to watch. So the child wasn't in the presence of the jury. The jury was able to observe the child's demeanor because they were able to actually observe the child communicating with both the defense attorney and the prosecutor on direct and cross-examination. So that's basically how it works. You have children victims in child abuse cases, child endangerment cases, child neglect cases. It's routine for that to happen. And then, of course, you have child witnesses. Sometimes children see things that we wish that they wouldn't have seen. The police wind up speaking with them and documenting the fact that they're witnesses. The rules require the state to advise the defense of any potential witness, regardless of age. And then you have to litigate those issues and figure out whether or not that kid is going to be competent to get up there and tell their story.
Thank you, Attorney Haber. Very, very valuable information. And I want to thank all the attorneys, definitely. And I want to remind all our viewers at home to give us a call. That number is 888-88-LEGAL, and that call's free. The consultation is free. Jennifer, why don't you...
That's right, Jackie. And, for me, these issues with children, especially children that are victims of sexual abuse or any sort of physical abuse are really close to my heart. As a former high school teacher, I've witnessed children that were being abused at home, and it really is heartbreaking. And for those of you that are at the local level, Miami is one of the #1 cities in the world for human trafficking, and this is something that's very serious. So we do have to take a quick commercial break, but if you are a victim or your child has been a victim, denounce these people. Take it to the police, because they do it once, they're going to do it again, and they're going to continue to be victims. So we'll be right back before the break, and we'll continue to talk about family and criminal law and the intersection of both.
I know you're home right now asking yourself, how? How will I pay my rent, my mortgage, my bills, my credit card debt? I'm attorney Alexis Garcia with PraDa Law. I've personally helped people with financial problems over the last 10 years. I understand what you are going through. We saw people lose it all in the 2008 financial crisis. You don't have to lose it all. The consultation is free. Call us now. I will help protect what you have built. You have nothing to lose by calling us. Call us now. These are trying times. This deadly virus is affecting our health, economy, jobs, our small business owners. Bankruptcy protection may be able to save assets and immediately stop your creditors from harassing you. Small business owners, employees of business of any size, we know you need help. Call us now. We will help you get back on your feet. Don't wait until it's too late. This is the time to call.
Sé que estás en la casa ahora mismo preguntándote, ¿cómo? ¿Cómo voy a pagar la hipoteca, la renta, los biles, las tarjetas de crédito? Soy la abogada Jennifer Pratt con PraDa Law. Yo personalmente he ayudado a las personas con problemas financieros durante los últimos 10 años. Yo entiendo por lo que estás pasando. Vimos cómo la gente lo perdió todo durante la crisis financiera del 2008. No tienes que perderlo todo. Llama ahora. La consulta es gratis. Te ayudaremos a proteger todo lo que has construido durante todos estos años. Sabemos que estos son tiempos difíciles. Este virus mortal está amenazando nuestra salud, nuestra economía, nuestros empleos y a los propietarios de nuestras pequeñas empresas. La consulta es gratis. Llame ahora. Te ayudaremos a recuperarte. No esperes hasta que sea demasiado tarde. Llame ya.
And welcome back to PraDa Law Live. I'm your host, Jackie Mendez, and we've been talking today with attorney Mike Haber, attorney Dan Silver, one of our partners here at PraDa Law, and we've been speaking a little bit about criminal law and labor laws, ladies and gentlemen. I'm sorry, family law. And so on the screen is a number that you can go ahead and call. It's a toll-free number. It's a consultation is free, 888-88-LEGAL, and Jennifer is going to go ahead and continue.
That's right, Jackie. And the days sort of blend in at times. So one day we're talking labor, one day we're talking bankruptcy, but today we're talking family law, criminal call. I invite you to give us a call. The first consultation is free. If you've been arrested and accused of any crime, give us a call. If you're having family issues right now, give us a call. And I know that with COVID, there's been a lot of people that have either found themselves in a relationship that they no longer want to be in, or difficulty exchanging the child and exercising time sharing. So this is the time to call. If you're facing any sort of financial circumstance that now you can't pay your child support, you can't pay that alimony, give us a call. We can try to help you at our office. And before the break, Attorney Silver and Attorney Haber were having what I like to call some nerd talk, and they were adamantly arguing, but in a good way. Let's call it debating, just like our channel, right? Debate TV, just debating about privilege. And it's not the kind of privilege that you've been hearing about on social media lately. It's a privilege that's actually in the cases that we're talking about. And I'd love for one of you to explain to me, what is this privilege thing that you're talking about?
So first off, when you meet with me, our communications are attorney-client privileged. And sometimes when someone's testifying to a court, someone might say, hey, my attorney may have said, and right away that good attorney should objection, attorney-client privilege, that is 100% privilege. And in Florida, we also have accountant-client privilege, we have husband-wife privilege, we have psychotherapist-patient privilege, we have all sorts of different privilege communications that should never be admitted in court. We were also talking about child hearsay, and Attorney Haber was talking about a hearing that he had where a child was went into chambers to testify in camera, which also happens in family court. But please be aware that this isn't something that happens on a whim. There are pretrial motions filed in regard to any sort of child hearsay issues. These child hearsay issues are litigated, and you need to have a competent counsel that knows the rules of evidence in order to either admit or exclude these child hearsay statements, depending on what they're offered for.
So in my example, I didn't necessarily go to child hearsay because that was actually a separate hearing that we had. That was what I was talking about, was child testimony. But the child hearsay is when in my context, the state wants to have a third party come up and say something that the child said to them. That's child hearsay, right?
Daddy hit me.
Huh?
Daddy hit me.
Daddy hit me. Or, daddy said mommy, was whatever. Whatever the case may be, it's a statement made by a child to a third party that the government is seeking to elicit, or in family court that the other party is seeking to elicit through a third party.
For the truth of the matter asserted.
Right. So that would be the issue with hearsay. And in the criminal context, you have a whole evidentiary hearing for the admissibility of child hearsay. Those witnesses that the state would like to call need to come in. Actually, the state first has to put you on written notice of who they want to call and what it is that they want them to say. Then those people are going to have to come into the courtroom. Obviously, there's no jury. This is just done in the presence of a judge. And the two sides will litigate whether or not those statements are going to be legally admissible over the hearsay exception.
Are they trustworthy? Are they reliable? Does the child know right from wrong?
And are they relevant? Right. Because a lot of times you have statements that are made that are just completely extraneous to the issue at hand. For example, the case we were talking about earlier, where the issue was whether or not the father who was accused of child abuse had injured the child. The statements that the child had made to the teachers about all the bad things that daddy said about mommy were not relevant to that fact. So they had no place in that case except to prejudice the father by making him look bad.
And also, is there a chance that this child is being coached by one of the parents? We see that very frequently in family court, and I'm sure in criminal court as well.
Absolutely. And, the other thing I would want to touch on in regard to privilege that you kind of mentioned, you talked a little bit about the psychotherapist-patient privilege. And I think that's a really good dovetail between our two areas of law, because in a lot of cases, we involve therapists. And it's the whole point of therapy, and the reason that we have this privilege, is because you want people to feel free to disclose things to their therapist that they wouldn't tell the rest of the world, because they know that the sanctity of that relationship, the sanctity of that environment can never be breached, right? Nobody can compel that to come out.
I mean, in family cases, you're always seeing children receive some sort of therapy, and then one parent may say, hey, I want to get the child's records, I want to get the notes, and one parent may think that they could waive the psychotherapist patient privilege on behalf of the child. And no, it's not the parent's privilege to waive, it's the child's privilege. So if you have two parents that are caught up in some time-sharing dispute, one parent simply can't just say, I want to waive this child's privilege, because again, then the child would not feel comfortable in therapy, and it would upset the entire reason the child's in therapy. And that's why if someone needs to talk to the therapist, a guardian ad litem could be appointed. The guardian could talk to the therapist can talk to the guardian without revealing any privileged communications, can still make recommendations as the child's best interest.
But you can blow that privilege real easy too, right? Because let's say you're spouses and you're in your own therapy session and you invite your wife to come into the therapy session, bye-bye privilege.
You can't have. I mean, that would not be a privilege if there's two people. That's correct. That's correct.
Well, I want to definitely thank our attorneys today, Mike Haber, Daniel Silver, one of our partners here, and I'm Jackie Mendez. Thank you for joining us here at PraDa Law Live, and of course, Jennifer Pratt.
Thank you, Jackie. And I told you guys that we were going to have a wonderful debate, a bunch of nerd talk, which I love, but it's so important. If this is affecting you, your family, your children, give us a call. The first consultation is free. As you can see, we have very passionate and experienced attorneys that know the law, that know the intricacies of evidence, and that will be able to represent you adequately. I hope you join us next time. Thank you so much. And up to next time. See you next soon.